A massive 6-3 Supreme Court victory just dropped, and over 600,000 people are about to feel the impact immediately. This ruling came down in the explosive battle between Homeland Security, lower court judges, and activist organizations who have been fighting for years to keep temporary protections permanent. The Supreme Court said enough is enough, and the power to enforce our immigration laws is back where it belongs with the executive branch. We're breaking down exactly what this means, who's panicking right now, and why this could be the biggest deportation case of the year. Hit that subscribe button because these Supreme Court decisions are coming fast, and you need to know how they affect you and your family. The Supreme Court handed down their decision with a 6-3 vote, and the numbers tell a story that most media outlets aren't covering completely. We're talking about 600,000 individuals who had what's called temporary protected status. But here's what makes this case absolutely critical to understand. The average person with TPS has been in the United States for over 12 years. 12 years on a status that has the word temporary right in the name. Think about that for a moment. How does something temporary last more than a decade? The Supreme Court looked at this situation and said the executive branch has the authority to end these protections without getting permission from lower court judges who have been blocking enforcement for years. What's fascinating is that TPS was originally created back in 1990 as a short-term humanitarian response to natural disasters and armed conflicts in foreign countries. It was supposed to last 6 to 18 months maximum. The idea was simple. If a hurricane destroys Haiti or an earthquake devastates El Salvador, we give people from those countries temporary refuge until conditions improve enough for them to return safely. But bureaucratic extensions turned months into years and years into decades. Nobody ever went home because every time the deadline approached, advocacy groups would pressure the government to extend the status again. The government's argument in this Supreme Court case was simple and logical. If one administration can grant temporary status under its executive authority, the next administration can remove it under that same authority, and the Supreme Court agreed with that reasoning. Judge Edward Chen sits on the federal bench in the Northern District of California, and he's been the main roadblock to ending these protections for years. Before President Obama appointed him to the federal bench in 2011, Chen spent years as a staff attorney and national board member of the American Civil Liberties Union. Let that sink in for a moment. The same ACLU that's been fighting these deportation cases in court is the exact organization that trained and employed the judge who issued the injunction blocking the government's actions. Chen has ruled against immigration enforcement in over 40 separate cases since taking the bench. His courtroom in San Francisco has become the go-to venue for immigration activists because they know exactly what they're going to get from him. In this particular case, Judge Chen issued an injunction that stopped the government from ending TPS for Venezuelans and Haitians, claiming the administration didn't follow proper procedures. He extended the protected status multiple times, pushing the deadline from month to month and creating what legal experts call injunction creep. That's where temporary court orders become quasi-permanent because they keep getting renewed over and over. The Ninth Circuit Court of Appeals backed him up completely, which is exactly why this had to go all the way to the Supreme Court for a final resolution. Justices Ketanji Brown Jackson, Sonia Sotomayor, and Elena Kagan formed the dissenting bloc, and Jackson wrote a lengthy opinion that reads more like an activist brief than a legal analysis. She spent 14 pages describing the humanitarian crisis in Venezuela, talking about economic collapse, political repression, and lack of basic services like electricity and clean water. Her dissent argues that sending people back to difficult conditions is inherently cruel regardless of what the law actually says about temporary status. But here's the massive problem with that logic that nobody in the media wants to address. Using that same standard, almost every developing nation on Earth could qualify for permanent protected status. There are currently 54 countries where the State Department has issued travel warnings due to crime, instability, poverty, or poor infrastructure. If we establish a precedent that we can't deport anyone to a country with problems, we've essentially created open borders through judicial decree. Any country with economic struggles or political instability would automatically qualify. That's not what Congress intended when they created TPS as a temporary humanitarian measure. Jackson's dissent also claimed the administration didn't provide adequate reasoning for ending the protections. But the majority opinion pointed out clearly that the law doesn't require the government to explain why a temporary program is ending. Temporary means temporary. It doesn't require a dissertation on why something that was always supposed to be short-term is finally ending. Over the past 8 years, federal district judges have issued more than 300 nationwide injunctions blocking immigration enforcement policies. Think about the scope of that judicial power. A single judge in one district can halt enforcement across all 50 states with the stroke of a pen. This Supreme Court ruling does something that goes far beyond just this one case about TPS. It sends a clear signal to lower courts that they can't keep substituting their personal judgment for the executive branch's constitutional authority on immigration matters. The Constitution gives Congress the power to set immigration law and gives the executive branch the power to enforce those laws. Nowhere does the Constitution say a district court judge can override enforcement decisions simply because they disagree with the policy on humanitarian or political grounds. What's been happening for years is a practice called forum shopping. Activist organizations file their lawsuits in specific districts where they know judges will be sympathetic to their cause. They get nationwide injunctions that apply everywhere, not just in that particular district. Then the appeals process takes years to wind through the system, and during all that time the injunction stays in place. By the time the Supreme Court can finally review the case, the temporary status has been extended so many times that advocates argue it would be cruel and disruptive to end it now. It's a calculated strategy to run out the clock and create facts on the ground that make deportation seem unreasonable. The media keeps saying 600,000 people lose their protections, but that number is actually conservative and doesn't tell anywhere close to the whole story. Venezuela accounts for roughly 350,000 individuals with TPS. Haiti adds another 250,000 to the count. But there are also protected populations from El Salvador, Honduras, Nicaragua, Nepal, Sudan, South Sudan, Syria, Ukraine, and Yemen. When you add up every country that received TPS designations over the past 15 years, you're looking at potentially 1.2 million people. NOT, all of those, will lose protection immediately because some countries still have valid designations that haven't been challenged yet in court. But this Supreme Court ruling establishes the legal precedent that any of them can be ended without courts interfering in the executive branch's decision. The economic impact is significant too, and it's worth understanding both sides of this argument. These individuals have been working legally for years or even decades, paying into Social Security, holding jobs, signing apartment leases, and putting kids in public schools. The argument from the dissenting justices was that suddenly removing work authorization would cause chaos in communities and businesses that have come to rely on this labor. But the counter-argument from the majority is that keeping people here indefinitely on temporary status actually creates even more chaos in the long run because it incentivizes more illegal immigration. If everyone knows that temporary really means permanent, and that advocacy groups will sue to keep extending protections forever, then more people will try to enter illegally, hoping to eventually qualify for some protected status. It undermines the entire legal immigration system where millions of people wait in line for years trying to come here the right way. The Supreme Court didn't just say the current administration can end TPS for these specific countries. They said any administration can end any temporary immigration program without having to justify it to federal judges. That's a huge shift in the balance of power between the branches of government. For decades, immigration policy has been made through a complicated combination of congressional statutes, executive actions, and judicial interpretations. Courts have been willing to step in and say an executive action violated the Administrative Procedure Act, or didn't have adequate justification, or didn't consider alternatives properly. This ruling says when it comes to temporary immigration statuses, the executive branch has almost unreviewable discretion. If the next president wants to end DACA, the Deferred Action for Childhood Arrivals program, this precedent supports that action. If a future administration wants to terminate temporary protected status for every single country simultaneously, this ruling says courts can't stop it based on procedural arguments about not following the right process. The majority opinion specifically rejected the idea that the government has to provide detailed explanations or consider alternatives before ending a temporary program. Temporary programs can be ended because they're temporary. Period. That's the entire point of calling them temporary in the first place. This is going to embolden the current administration to take actions they might have hesitated on before, knowing that courts are far less likely to block them now. For years, administrations of both parties have been reluctant to make bold moves on immigration because they knew activist lawyers would immediately file suit in a friendly district and get a nationwide injunction within hours. That created a chilling effect where the executive branch couldn't fully exercise its constitutional authority. This Supreme Court decision removes that chilling effect. It tells the executive branch that when it comes to temporary immigration programs, you have the authority to act, and lower courts need to stay in their lane. The deportation timeline is going to unfold over the next several months, and it's important to understand what actually happens in practice. For the 600,000 people directly affected by this ruling, their work authorization will expire on specific dates unless the government grants extensions. Without work authorization, they can't legally hold jobs. Without legal status, they become subject to deportation proceedings if Immigration and Customs Enforcement chooses to prioritize them for removal. The reality is that ICE doesn't have the resources to immediately deport 600,000 people. The agency has to prioritize based on criminal history, recent border crossers, and other factors. So what you'll likely see is a gradual process where some people leave voluntarily, some seek other forms of relief like asylum, and others eventually face deportation orders. Appeals will continue in lower courts, but those courts now have clear guidance from the Supreme Court that they can't block the termination of temporary status based on procedural arguments. State-level responses will vary dramatically. Sanctuary states like California and New York will likely refuse to cooperate with federal immigration enforcement and may even try to provide state-level benefits to people who lose federal protection. Other states will fully cooperate with ICE and may even use state resources to assist in enforcement. This creates a patchwork where your legal status and practical situation depends heavily on which state you're living in. Why isn't the media covering the full story here? Because the framing depends entirely on political perspective. Conservative outlets emphasize the rule of law, the constitutional separation of powers, and the fact that temporary was always supposed to mean temporary. Liberal outlets emphasize the humanitarian concerns, the disruption to families and communities, and the conditions in countries people would be deported to. But what almost nobody's covering adequately is the forum shopping angle, the injunction creep problem, the judicial activism of judges like Edward Chen with clear ACLU backgrounds. Most stories say 600,000 when the reality is closer to 1.2 million potentially affected once you count all the TPS countries. The precedent this sets for DACA and other programs is barely mentioned in most coverage. This Supreme Court ruling just shifted the entire balance of power on immigration enforcement, and we're going to see the effects play out over the next few months as more cases hit the courts with this new precedent in place. Lower court judges who have been blocking immigration enforcement for years now know the Supreme Court will overturn their injunctions. Activist organizations that have been forum shopping to friendly districts now know that strategy has a much lower chance of success. And future administrations now know they have clear authority to end temporary programs without endless litigation. This is one of the most significant immigration law decisions in decades, and it's going to reshape enforcement policy for years to come. If you want to stay updated on these major legal decisions that actually impact your life and your country, hit that subscribe button and turn on notifications so you don't miss the next breakdown when the next major ruling drops.